As an NRI, what are the 6 things to watch out for when you are buying vacant land in India? Vacant land in India is a bit of a double-edged sword because on the one hand, over the last 10 to 15 years, prices have skyrocketed. On the other hand, you have fairly opaque laws that govern these lands, which creates risk. And these laws change from state to state or even from district to district. And for a layman, it is absolutely confusing as to how or what are the things to watch out for when you are buying vacant land in India, especially from a legal standpoint. In this video, I'm going to talk to you about 6 things that you must watch out for when you are buying vacant land in India. My name is Ramana Reddy and I'm a civil litigation lawyer practicing in India. On this channel, I help you by simplifying complex legal concepts. For tips, tricks, and general legal information, make sure you hit the subscribe button below. The first thing that you need to watch out for when you are buying vacant land in India is that you need to actually physically visit the vacant land before you buy it. The most common mistake is that an NRI who's living halfway across the world will send somebody whom he trusts to the property just to go and verify, just to go have a look, and then they just transfer the money and the sale is done. I don't think that is a great idea at all, because no matter who you trust, ultimately when you're paying that much money, it is important that you go and physically verify who is in possession of the property. The person who you send, he may have good intentions, but he may look at the wrong piece of land just because he doesn't have as much interest as you do in that piece of land. So he may just show up with the wrong land, for example. And so therefore it is important for you to verify, number one, who is in possession of the property, because you don't want to buy property if somebody else is already in possession and just buy a dispute for yourself. The other thing to watch out is what are the boundaries to the property, and the other thing to watch out is, you may have, say, 2 or 3 factors in your mind that if a property qualifies these 3 factors, I'm going to buy it. So you may say that a land should be, say, 5 kilometers from the highway, for example, only then I'm going to buy it. And you send somebody and they're just going to give you their opinion on what they think, and you're going to make a decision based on their opinion on what they think, which is again hearsay, not advisable. Also because, once you actually physically visit the property, there may be a 4th factor, a 5th factor that could influence you to buy or not buy that piece of land. So I think it's extremely important that you visit that piece of land before you actually buy it, just to verify physical possession, is to verify boundaries, and just to think about what factors are important to you, because ultimately this is a personal decision. So what factors are important to you when you are making this purchase, or when you refrain from making this purchase, at least so that you are clear in your mind. Moreover, the person who is selling the property to you is a total stranger. I mean, if you're buying it in a village, it could be a villager. If you're buying it in a city, it could be somebody who's selling you a plot. You don't know these people, and halfway across the world, you guys are separated by distance. Don't just trust them. Actually go there, verify that piece of land, and trust me, that is a decision you will be happy with, and you will buy yourself some peace of mind. The second thing to watch out for is, or the second thing to actually get, I guess, is the title document of the seller. So if the seller says he's the owner of a particular piece of land, so you ask him, okay, show me your title document. What is the document that gives you title? Now it could be a gift deed. Maybe his parents or his friends have gifted the property to him. Maybe he purchased the property, so there may be a sale deed, or there may be a family partition under which he got that piece of property. And there could be multiple ways in which he has acquired that property. So it is important that you take from the seller a copy of the title deed through which he becomes the owner of the property. So that is the second important thing. The third important thing, and this I think is a big point, is that you need to not just take the title document of the seller, but you need to go back, say, 30 years in time, at least 30 years in time, and try to figure out what is the history of that property. Who has purchased this property? So let's say, A sold to B, B sold to C, C sold to D, D sold to E, E sold to F. All right, so we have all these transactions. So from A to F. So let's see on what dates were these transactions entered into. There was a sale in 1970, 75, 80, 85, and so on. So what are the dates of these sale deeds? Are the names of the parties properly reflected, and so on? Now this is it helps you get a bird's eye view into the history of the property. Now, why is this important? Because the next step as to what you will do is that you will take this title on the one hand, and on the other hand, let's say that you're buying a plot within a city, right? You will go and you will obtain something called an encumbrance certificate from the municipality, because the municipality also maintains records as to who is the owner of a particular piece of property. Then you're going to take, the municipality's list, and then you're going to take the list that is furnished by the seller, and you're going to compare, does it match? Is it like, did it come from A to B, B to C, C to D, and so on? Or is it like, A, and then somehow C came into the picture and B's name is not there. It's not there. Why is it not there? And these things you want to know beforehand. You want to know before you buy the piece of property, because you don't want to enter into the deal just on the basis of the title deed of the seller and then find out that your seller in fact did not have title. And that is the reason why you look at these link documents, as they call it, or these predecessor documents, because you have to verify that the seller who is actually selling you that property has title, because one of the basic principles of law is that a seller cannot give better title than what he has. So if there is a defect in his title, that defect is going to be passed on to you as well. So it is important that you verify not just the seller's sale document or the title document, but you also go back at least 30 years in time and try to verify how this property came from one party to another party. The other thing to ask the seller of the property is there a loan on that piece of property? Does he have the original document with him? Because although a loan is generally reflected in the public record with the municipality or in the revenue records, if it is there's one type of loan, it's called a memorandum of deposit of title deeds, where you mortgage property, that will not reflect. So it is important that you ask him, is there a loan on this piece of property? Now, the other thing to keep in mind is if the seller has got it through a family partition, even if the partition is registered, just from a legal standpoint, as your lawyer, I would be most comfortable if his other family members also sign, or at least willing to sign, as consenting parties when he makes the sale to you. Because, tomorrow they should not come and say, look, my brother got this signed without my consent. He told me that just sign this paper, there's nothing in it, but 10 years later I find out that he played a fraud on me and so on. So you don't want to get into all that. If he gets it through a family partition, or if he has or if that property is somehow connected to his family properties, it is always advisable that you get his family members also to sign the document through which he will sell to you. Also, when you're looking at link documents, there are two specific documents that you need to watch out for. The first specific document is something called an agreement of sale cum general power of attorney. So there was this time when people would, just to avoid stamp duty, instead of executing a sale deed, they would execute a type of document. Its nomenclature, what was called, was an agreement of sale cum GPA. Now I have a separate video about that, what that means. Make sure you click the link above where I discuss that in detail. But basically, in a case called Suraj Lamps in 2011, the Supreme Court said that if you try to transfer title through an agreement of sale cum GPA, then title will not validly transfer. So let's just go back to our example. Let's say A sold to B through a sale deed, B sold to C through a sale deed, C sold to D not through a sale deed but through an agreement of sale cum GPA after 2011. And in that case, what happens is there is a defect in title, because if you see an agreement of sale cum GPA, there are likely to be some legal issues, and it is best that you consult a lawyer, at least insofar as that particular chain is concerned. So that is one thing to watch out for. The other thing to watch out for is agreement of sales. Now this is typically one of the hardest things to do, because all other documents, so in India the law is any piece of land that has to be sold only through a registered document. And once it is registered, anybody can access it, anybody can scrutinize the document. But there are some exceptions to this rule, and that is the agreement of sale. Now, what is the agreement of sale? Agreement of sale is basically, let's say I have a piece of property and I want to sell it at say 1 crore. There was, some person walks up to me and it's like, Ramana, how about I give you 10 lakhs today, right? And I will pay you the balance 90 lakhs after say 6 months. So I'll pay you 10 lakhs today, 90 lakhs after 6 months, and we will enter into an agreement of sale where I have the first option to buy from you. You cannot sell to anybody else. And by law, you are actually contractually bound to sell to me, unless I don't pay within, those 6 months. I have seen so many cases where, unscrupulous sellers, what they do is they enter into an agreement of sale. So Ramana will take the 10 lakhs from somebody and then he turns around, oh, here's an NRI who wants to buy my property and I just sell it to you. And I basically get the double benefit. And you're stuck with the litigation with the guy who paid me 10 lakhs. And as a lawyer, it is difficult because these agreement of sales, they are not compulsorily registrable. So you cannot actually verify them in the public record. So when you're trying to buy vacant land in India, it is important that at least you make some local inquiries as to who the seller is. Is there any agreement of sale? If you're going through a broker, which I will get to shortly, but you're going through a broker, then it is important that the broker also make his set of inquiries in that particular area to see if anybody is an agreement holder, so that, you don't just get cheated like that. Now, once you're cheated, you may go and file a police complaint, but you may just be buying a headache instead of actually buying property that will benefit you. Also, if there is agricultural land, then, a lot of states have their own portals. For example, I'm from Telangana. I can tell you, in Telangana, they have something called the Dharani portal, which is, which helps people, which has mapped out all the survey numbers, at least as far as agricultural land is concerned. And that is something to look at if you're buying agricultural land. The next thing to look at is the market value certificate, because along with the actual sale consideration or the price for the land, you would also have to, shell out stamp duty, which is generally about 2 to 5% of the market value. You'll have to pay something for registration, which is about about 0.5%, and some other fees. So that is also something to be kept in mind. Also, while we are on the topic of registration and sub-registrars, who will ultimately, whose office you'll have to go to, or if you have a GPA, then that person will have to go to that office. Sub-registrars also maintain something called a prohibited list. And that prohibited list will contain a list of all survey numbers which are prohibited in the interest of public policy not to register any documents in those survey numbers. So even if the title flow and everything matches, if the survey number in which you plan to buy, if that survey number is, finds place in the prohibited list, most likely the sub-registrar will not transfer or will not execute a document in your favor. So that is also something that you must check up. The next thing to watch out for is obviously brokers. Brokers, again, they're another double-edged sword. They help you find property, but they're also sometimes out to screw you. So you need to deal with brokers at an arm's length distance. Brokers help you find property because they are brokers who specialize in particular parts of the city or particular parts of the country, and they know that area best because that is where they do all their sales. So these brokers are important for you because if you identify a good broker, then he will be able to show you 5 to 6 properties that are up for sale. But on the other hand, you need to have a frank discussion with the broker as to what will be the commission. Sometimes he may ask you for 1% of the entire sale value. But if the sale value is huge, you may not be inclined to give him 1%, so you may have to negotiate a flat fee with him. And more importantly, you need to ask the broker to introduce you to the actual seller. You need to meet the seller, you need to see his demeanor, you need to see how he behaves and whether he's trustworthy. The seller cannot just be a man, the man behind the curtain, and the broker is running the entire show. Because ultimately, the broker may say the price of the land is 1 crore. He may be taking 20 lakhs and giving the owner 80 lakhs or something like that. So you always need to meet the seller, and that is an important thing. Now, the final tip that I can give you and this is probably self-serving, is that invest in a good lawyer, because ultimately this is not your area of expertise. You may be in IT, you may be a doctor, you may be a journalist, you may be whatever field that you're pursuing. Don't try to do this on your own as a lawyer. That's not, at least that is my view. You can try to do it, but invest in a good lawyer, because when you're trying to buy property worth crores, it is important that you get a proper legal opinion so that somebody who is an expert in the subject can do due diligence for you. And when you're picking that lawyer, ensure that the lawyer has some experience not only in real estate but also some experience in civil litigation, because only when you see actual disputes, will somebody be able to advise you on whether this is a good decision, bad decision. I hope that video was helpful. Thank you for watching.